Hello and welcome to In Depth. I'm Tina Jha. The Modi government defeated its first no-confidence motion in Lok Sabha on the 20th of July. In the course of the debate, many things were said. A few of these remarks from the ruling party side as well as the opposition became the subject matter of privilege motions. It started with the BJP moving 4 privilege motions against Congress President Rahul Gandhi, accusing him of misleading Parliament by making false allegations against Prime Minister Narendra Modi and Defence Minister Nirmala Sitharaman. The Congress then served 5 privilege notices against Prime Minister Modi and Defence Minister Sitharaman, also accusing them of allegedly misleading the House on the Rafale deal issue during the debate on the no-confidence motion. Both notices, in fact, are under the consideration of the Lok Sabha Speaker. Today's In Depth is all about understanding the privilege motion, the rules governing privileges in both houses of Parliament, the procedure to move them, and the role of the chair in admitting or rejecting a notice. So the debate on the no-confidence motion in the Lok Sabha on the 20th of July triggered a clash of different kind between the ruling party and the opposition. This was the clash of privilege motions. First, the BJP moved a notice for privilege motion against Congress President Rahul Gandhi. 2 days later, the Congress responded with a privilege motion notice against the Prime Minister and the Defence Minister over the Rafale deal. This is how the charges and counter-charges were exchanged. On 23rd July 2018, 4 BJP MPs moved a notice for privilege motion against Congress President Rahul Gandhi in the Lok Sabha. Submitting the notice, BJP MPs Nishikant Dubey, Anurag Thakur, Dushyant Singh and Prahlad Joshi accused Rahul Gandhi of misleading Parliament with what they called making false allegations against Prime Minister Narendra Modi and Defence Minister Nirmala Sitharaman.
He has given unfounded, baseless, non-verifiable statement against the Honourable Prime Minister, and he has said that he has cheated the nation, he has cheated the army. Let him prove it, and he cannot make hit and run case, तो ये नहीं हो सकता है, इसलिए हमने privilege notice डाला है.
2 days later, the Congress responded, giving notices for privilege motion against Prime Minister Narendra Modi and Defence Minister Nirmala Sitharaman. 5 Congress members, including Mallikarjun Kharge and Jyotiraditya Scindia, submitted the notices to the Lok Sabha Speaker. The Congress alleged that the Prime Minister and the Defence Minister had misled the House on the Rafale deal during the debate on the no-confidence motion on the 20th of July.
The Rule 220 of the Rules of Procedure and Business Conduct in Lok Sabha, yes. I hereby give notice of my intention to move privilege motion against Prime Minister Shri Narendra Modi for making misleading statement in his speech on the debate of no confidence motion in Lok Sabha on 20th July 2018. Madam, this can be referred to the...
It is under my consideration. I will see to it.
222 रूल के तथागत, रूल 222 के तथागत हम लोग एक प्रिविलेज मोशन मूव कर रहे हैं रक्षा मंत्री के विरुद्ध, जिस तरीके से पूरे सदन को और देश को भटकाने की कोशिश की है, झूठे वादों के आधार पर, जहां रफेल डील के दाम को छुपाने की कोशिश कर रही है, जहां सरकार ने भ्रष्टाचार किया है.
It is under my consideration. That's all.
Responding to Congress's charge, Parliamentary Affairs Minister Anant Kumar said the BJP members who earlier gave notices for privilege motion against Congress President Rahul Gandhi should be given an opportunity to speak, after which the Speaker allowed Anurag Thakur to speak in the House.
अध्यक्ष जी, मैंने केवल आपके ध्यान में इतना लाना है, जिस दिन अविश्वास प्रस्ताव पर चर्चा हो रही थी तो माननीय राहुल गांधी जी ने सदन को गुमराह करने का प्रयास किया, तथ्यहीन आरोप लगाए, और उसके बदले जब रक्षा मंत्री जी ने जवाब दिया और फ्रांस के राष्ट्रपति जी ने भी वहां से उत्तर देकर कहा है कि दोनों देशों के बीच में जो संधि है और इनके खिलाफ कार्रवाई होनी.
यहाँ के 5 लोगों ने अलग अलग दी है, 5 लोगों ने अलग अलग नोटिसेस अगेंस्ट द प्राइम मिनिस्टर प्रिविलेज, 5 लोगों ने अलग अलग नोटिसेस अगेंस्ट रक्षा मंत्री. 5 की तरफ से मैंने केवल एक को कि एक को प्रधानमंत्री की बात बोलने दी, एक को रक्षा. ऐसा नहीं है, यहाँ से 4 नोटिसेस हैं, बट दैट वाज अगेंस्ट 1 person ओनली.
The notice and counter-notice for privilege motion came over the no-confidence motion in the Lok Sabha on the 20th of July. The debate saw Rahul Gandhi making allegations against the Prime Minister and Defence Minister over the Rafale deal. His charges were countered by the government and the ruling BJP. Bureau Report, Rajya Sabha TV. A breach of privilege is a violation of any of the privileges of Parliament or members of Parliament. A privilege motion in Parliament is granted precedence over ordinary business because it concerns matters of great importance or urgency. Such motions are not debatable, although in case of questions of privilege, the chair may feel the need to elicit relevant facts from members. Parliamentary privilege refers to rights and immunities enjoyed by Parliament as an institution and MPs in their individual capacity, without which they cannot discharge their constitutional functions. When any individual or authority violates these rights of the legislators, the offence is called a breach of privilege. Breach of privilege is an act in violation of the privilege or either House of Parliament, for instance, a false oath taken before a committee. Under Rule 222 of the Lok Sabha, a member may, with the consent of the Speaker, raise a question involving a breach of privilege either of a member or of the House or of a committee. Under Rule 223 of the Lok Sabha, a member wishing to raise a question of privilege shall give notice in writing to the Secretary General by 10 a.m. on the day the question is proposed to be raised. If the question raised is based on a document, the notice shall be accompanied by the document. The right to raise a question of privilege is governed by certain conditions. Rule 224 says, not more than one question shall be raised at the same sitting. The question shall be restricted to a specific matter of recent occurrence, and the matter requires the intervention of the House.
They are pending with the Madam Speaker, and she has to take a decision whether prima facie a case of deliberately misleading the House is made out. If it is not made out, she will reject the notice. And if she were to find that it is made out, then she can refer the matter to the Committee of Privileges.
The mode of raising questions of privilege have been mentioned under Rules 225 to 228 of the Lok Sabha. Rule 225(1) says, if the Speaker gives consent under Rule 222 and holds that the matter proposed to be discussed is in order, then he or she shall call the member who shall rise in his or her place and while asking for leave to raise the question of privilege, make a short statement. However, if the Speaker refuses to give consent under Rule 222 or is of the opinion that the matter proposed to be discussed is not in order, he or she may read the notice of question of privilege and state that he or she refuses consent or holds that the notice of question of privilege is not in order. And if the Speaker is satisfied about the urgency of the matter, then he or she may allow a question of privilege to be raised at any time during the course of a sitting after the disposal of questions. The House may consider the question and come to a decision or refer it to a Committee of Privileges on a motion made either by the member who has raised the question of privilege or by any other member.
The Speaker can even take the sense of the House, whether the House agrees with such a privilege motion to be taken further, and some members can take objection. The House stand up and object to it, then the Speaker can take note of that before taking any decision. But in the ultimate analysis, normally these privilege motions are referred to the Privileges Committee, which is constituted in both the houses, Lok Sabha and Rajya Sabha. Separate committees are there.
Under Rule 225(2), if objection to leave being granted is taken, the Speaker shall request those members who are in favour of leave being granted to rise in their places. If not less than 25 members rise accordingly, the Speaker shall declare that leave is granted. But if less than 25 members rise, the Speaker shall inform the member that such member has not the leave of the House.
The committee decides whether to take evidence, to hear both the sides. The person who has made the moved the motion, his evidence or her evidence is taken, and the person against whom the motion has been moved, his evidence is taken, and any other kind of evidence, documents, records the committee can ask for before coming to a conclusion. At the end of the day, the committee prepares a report and places it before the House. And then there is a provision for discussion on the report of the committee, and then the question is put that whether the House agrees with the report of the Privileges Committee or not.
Rule 226 says, if leave under Rule 225 is granted, the House may consider the question and come to a decision or refer it to a Committee of Privileges on a motion made either by the member who has raised the question of a privilege or by any other member. While Rule 227 mentions that notwithstanding anything contained in these rules, the Speaker may refer any question of privilege to the Committee of Privileges for examination, investigation or report. Under Rule 228, the Speaker may issue such directions as may be necessary for regulating the procedure in connection with all matters connected with the consideration of the question of privilege, either in the Committee of Privileges or in the House. In Rajya Sabha, Rule 187 in Chapter 16 of the Rule Book governs privilege. It says that a member may, with the consent of the chairperson, raise a question involving a breach of privilege either of a member of the House or of a committee thereof. The rules, however, mandate that any notice should be relating to an incident of recent occurrence and should need the intervention of the House. Bureau Report, Rajya Sabha TV. So what is a parliamentary privilege? It is a legal immunity enjoyed by members of certain legislatures. Privileges are classified into two groups. One enjoyed by the members individually and the other belonging to each House of Parliament collectively. More details in this report.
A member of Parliament or a member of Legislative Assembly is not just a public representative. Rather, they are patrons of the Constitution who make laws and policies. Together with the executive, they decide the present and the future of the country. Which is why, while discharging their duty, they should not be in dilemma or face obstruction. In addition to the prestige and importance of these posts, the Constitution has given them some privileges. Subjects related to these privileges come under Section 1 and 2 of Article 105 and 194 of the Constitution. The subject of privilege in the Constitution is taken from England. Articles 105(3) and 194(3) of the Constitution give the same privileges to the state legislatures as the House of the Commons. It has been clarified in the Constitution that these are independent provisions which do not come under Section 3 of the Basic Rights. This means that if any of the houses remove part of a dispute from the proceedings, then no one will be able to publish that part. If this happens, then it will be contempt of Parliament or legislature, which is punishable, and in this case, the basic right to freedom of speech under Article 19(1) cannot be argued. Later, the Supreme Court clarified in a matter that the cases of privileges are free from 19(1)(a), but they will be considered under Articles 20, 22 and 32.
The Constitution of India in Article 105 and Article 194 states what the freedoms, immunities are available to the members of Parliament and the Parliament. There is freedom of speech and expression, and there is immunity from legal action for whatever that is said in the House. Now, this is a very clear written privilege that is available to the members. In other respects, there are so many other privileges, and the Constitution says that till a law is made, our privileges shall be those which are available to the members of the House of Commons.
The matters of privilege can be divided into two parts. Firstly, individual privilege to every member, and second is the collective privilege to each House of the Parliament. Talking about the personal privilege of the members, first is the privilege of exemption from arrest. Under Section 135A of the revised Civil Procedure Code of 1976, a member gets exemption from arrest for 40 days before or after the House or committee meetings, but these exemptions are only in civil matters. This exemption is not for criminal or preventive detention cases. Second is the exemption from being present as witness. Under this, when the Parliament session is underway, a member cannot be summoned for the testimony. And third exemption is from the freedom of speech. Under this, a member of Parliament cannot be challenged in court for any statement made in the Parliament or its committee. These privileges to members are applicable till they are in the interest of the Parliament or the House.
In the present context, one of the privileges is that if a member or a minister misleads the House deliberately, knowingly, willfully, then he will be guilty of the breach of privilege. And the consequences shall follow. If the House decides that the member has been or the minister has been guilty of misleading the House deliberately, then they can punish the member.
The second part of the privilege is related to the collective privilege of each House of Parliament. Under this, members have the right to stop discussions and proceedings and other people from being published, the right to exclude or ban other people, right to settle the internal affairs of the House, right to publish parliamentary misconduct, right to punish members and outsiders for dissolving the privileges of the House.
There is no provision in the rules about what punishment can be given, but in the past sometimes the person who has violated the privilege of the members is reprimanded. Of course, there are cases in the state government when even some officers have been sent to jail, but that is all for the House to decide what kind of punishment they want to give.
Apart from this, the chairman and the Speaker of the House have the right to order any outsider to leave the House, to ensure smooth proceedings of the House, and in the event of dispute, the right to settle the cases internally without courts' interference. Another important thing is that the courts of India have also made it clear from time to time that a House of Parliament or state legislatures have the right to describe that if privilege of the House or the member has been violated or not. Bureau Report, Rajya Sabha TV.
A breach of privilege is a violation of any of the privileges of MPs of Parliament. Among other things, any action casting reflections on MPs, Parliament or its committees could be considered breach of privilege. This may include publishing of news items, editorials or statements made in newspapers, magazines, TV interviews or in public speeches.
Privilege motion is passed against any member of the House who is accused of breach of privilege. Besides members, Parliament has the power to punish outsiders for breach of privilege of the House. There have been many instances when Parliament realized its privilege has been breached and people were summoned and punished. The House can call the offenders, give them a warning and let them go or send them to prison as the case may be. There have been many such cases. One example is the weekly Blitz newspaper case in 1961, when its editor was held guilty of gross breach of privilege of the Lok Sabha. Blitz had allegedly published an objectionable article. The sample of privilege cases against the newspapers and media is enormous. Many cases, including those against the Searchlight newspaper from 1959 to 60, the Indian Express in 1964, the Times of India in 1965, the Statesman and Hindustan in 1973, the Hindustan Times in 1979, the Hind Samachar in 1980, and many others were about wrongful reporting. The media apologizes for its bona fide error and offer to publish a correction and an apology.
Honorable Speaker has the responsibility to check whether prima facie a case is made out in respect of any breach of privilege. And in this case particularly, she has also to ascertain whether not only there is a misleading, but it is a deliberate misleading, willful misleading, knowingly misleading.
The Constitution of 1950 gives legislatures virtually unlimited speech powers and immunity from anything said and done or spoken in legislative proceedings, including after the Supreme Court's decision in the Jharkhand Mukti Morcha MP's case for accepting bribes for voting. In that case, Supreme Court dismissed all cases against the 11 MPs as they came under the purview of Parliamentary Privileges Act. The Act ensures that members of Parliament are able to speak freely in debates and protects Parliament's internal affairs from interference from the courts.
Member feels that his privilege in what manner has been hurt, then he should give specific details of that. So once the privilege motion is moved, then the Speaker has to take a decision. The Speaker has to take a call on what to do with that motion. The Speaker can even take the sense of the House, whether the House agrees with such a privileged motion to be taken further, and some members can take objection. In the House stand up and object to it, then the Speaker can take note of that before taking any decision.
Clause 3 of Article 105 as amended declares that the privileges of each House of Parliament, its members and committees shall be such as determined by Parliament by law from time to time and until Parliament does so. Bureau Report, Rajya Sabha TV.
And that's it from us in this edition of In Depth. We'll see you same time tomorrow with a comprehensive view on another subject. You can also watch our episodes online on YouTube and Twitter and get back to us with your feedback and suggestions. Thanks for your time.